Will the Justin Baldoni Blake Lively case go to trial? We got Ron Zambrano here to break it down. Welcome to Popcorn Planet. I am Andy Signor. So glad to have Ron back. How are you doing, sir?
I'm doing great, Andy. I'm really excited to now nerd out on this lawyer stuff.
Yeah, there's a lot that's coming in. Shout out Eric Gardner over at Puck, who put together a really good piece. Because I was there too, and he put together, and actually I now have been in touch with Eric. I hope to get him on the show because I want his insight on the show because he's been covering this for a while as well, Ron, and I'm sure he'll be excited to hear your take as well on some of these notes because, guys, now that we have the hearing happen, now that things are there, now that we know what all the things are.
The sexiness in this film and the marketing, I'm sure, is critical to a success. The words hung heavy in the courtroom, Blake Lively's own private communication, now a public weapon. Justin Baldoni's legal team presented this unassailable evidence, revealing her explicit demand for a sexy and grown-up movie, directly contradicting her claims of offense. This strategic leak of her internal messages instantly shifted the entire narrative, leaving Lively's argument reeling. The court saw her own vision for the film, making her subsequent allegations appear deeply inconsistent and causing palpable tension among her counsel. The impact was immediate and devastating, raising serious questions about her motivations.
Show because he's been covering this for a while as well, Ron, and I'm sure he'll be excited to hear your take as well on some of these notes because, guys, now that we have the hearing happen, now that things are there, now that we know what all the things are, which I have them here, all the causes of action, there were 15, 2 of which dropped. There's now still 13 of which we're waiting for Lyman to make a ruling on. And Eric put together a really good piece on Puck. I love the Puck newsletter. You guys should support it. But he goes in and he really made some interesting points. And he said, look, regardless of all the text, everything else, what you really should be looking at is what happened behind the scenes on NBC's Friends, which is true. This lawsuit, which you guys should look into, Lyle versus Warner Brothers, was a big part of the conversation in.
This wasn't an isolated comment. Baldoni's defense doubled down, exposing more of Lively's personal notes to the film's production. Sex is important. We need this to be heat. We need things to feel sexy and grown up, and even outside the bedroom. Sexy and grown up to deliver for an audience expecting our rated movie. These stunning revelations, her own directive for the film's tone, were laid out as irrefutable proof. Her legal team watched as the very foundation of their case crumbled under the weight of her own words, demonstrating her active participation in crafting the film's adult themes. The strategic release of these communications painted a picture far removed from her public statements.
On NBC's Friends, which is true. This lawsuit, which you guys should look into, Lyle versus Warner Brothers, was a big part of the conversation in the hearing room, as was another one, McSweeney versus Bravo, Andy Cohen. These two cases, this one actually was decided by Lyman, ironically. So both of these Eric brought up in a good way and explained it a lot better. So yeah, Jonathan Bach, one of Baldoni's attorneys, kept bringing up this Friends argument, saying, well, look, because the Friends team was, the writers were talking about sort of, stuff behind, you're not supposed to, inappropriate things. This writer's assistant, Amanda
Baldoni's attorneys expertly invoked the Friends lawsuit, a critical precedent in Hollywood, to defend the creative environment. They argued that the often raunchy, sexually charged humor in a writer's room, though potentially inappropriate in other workplaces, is integral to the development of adult-themed content. This established legal protection for creative freedom became a powerful shield, suggesting that participants implicitly consent to the uninhibited, sometimes provocative, discussions inherent in filmmaking. The defense asserted that this crucial case highlighted the necessity for artists to explore sensitive themes without constant legal scrutiny, directly challenging Lively's core complaint.
We're talking about sort of, stuff behind, you're not supposed to, inappropriate things. This writer's assistant, Amani Lyle, sued Warner Brothers after she was fired, claiming they, were making fun of her and it was harassment, et cetera, et cetera. The judge ultimately deemed that this was a creative space, correct, Ron? Can you sort of walk through, you're going to explain this better. What was this case briefly and how does this play to and the importance of the Blake Lively, Justin Baldoni case?
Yeah, so this is one of a few cases that a lot of people that work in the creative space rely on when they are sued for things that they do in the creative space. So in the Friends...
The Judge Lyman had previously ruled on the McSweeney case, involving a Real Housewives star and alleged exploitation of alcoholism for a storyline. This precedent, also cited by Baldoni's team, established that reality TV producers are permitted to include elements like alcohol, and cast members implicitly consent by participating. Lyman's earlier decision underscored the concept of inherent risk and consent within entertainment, reinforcing the idea that individuals enter these creative spaces with an understanding of their nature. This historical ruling further bolstered the defense's argument, suggesting a pattern of judicial protection for creative liberties in the industry.
The lawyer argued that no, countered the distinction, saying that Baldoni and Heath targeted her specifically rather than just subjecting her to generally inhospitable atmosphere. The relevant issue, Hudson argued, was consent, and Lively never gave it. They brought that up a lot, Ron, about, well, no, she didn't give consent when they're doing the dance scene and they're doing this lean in, and Justin's team's like, this is ridiculous, Your Honor. We're literally here in federal court asking because of a lean in and a graze. And he's right. It's absurd that we're here for this. But Ezra made it over and over again when Lyman pushed it. Well, no, she didn't give consent for that. You have to give consent for physical touch. And
Lively's lawyer, Ezra Hudson, struggled to counter, claiming that Baldoni specifically targeted her, not generally. Hudson's primary argument hinged on a lack of consent for physical touch, a lean-in, or a graze during filming. This narrow focus, however, seemed to miss the broader context established by the defense, appearing almost trivial against the weight of the Friends and McSweeney precedents. The reliance on such minor physical interactions as the basis for a major lawsuit struck many in the courtroom as disproportionate, particularly given the adult themes Lively herself endorsed for the movie.
That we're here for this, but Ezra made it over and over again when Lyman pushed it. Well, no, she didn't give consent for that. You have to give consent for physical touch. And it looks like you read the notes. Lyman was like, well, but any improv now needs to be determined by a jury. I mean, do you agree with Lyman's pushback? Where do you think this is heading, and who's going to win this fight?
I think again, I wasn't there, you were there, but as far as what I've been reading, what you've been reporting, and what Eric has put here, I think Lyman will find like in Lyle, which is the conduct that has been brought up in the lawsuit and the conduct that's being brought up as supposedly
Judge Lyman pushed back hard on the consent argument, questioning the practical implications. If kissing is off limits, directors have the ability to improvise. What about a hand on an actor's back? He pointed out that if consent were the sole measure for every minor interaction, every improvisation would require a jury decision, effectively crippling the creative process. The judge's skepticism highlighted the absurdity of policing every spontaneous moment on a film set, especially for an adult-rated production. His pointed questions exposed the logistical nightmare such a standard would create for the industry.
To Justin, her notes for the film: sex is important. We need this to be heat. We need things to feel sexy and grown up, and even outside the bedroom, sexy and grown up to deliver for an audience expecting an R-rated movie. I mean, this just destroys her argument when whatever. And literally, it feels like it's come down to 4 issues that I heard in that hearing, Ron, and one of them is still he was calling her outfit sexy. I mean, how could this still happen when Blake has all these statements saying it herself?
Right. So as a lawyer or the judge looking at it, it's more of, okay, we're looking at this conduct. Is it based on sex?
The judge's line of questioning strongly implied his inclination to rule that the alleged conduct fell within the accepted baseline of a creative environment. Lyman suggested that simply being part of the creative process for an adult-themed movie constitutes implicit consent to exposure to its narratives and themes. This judicial stance suggested a strong likelihood that he would view the actions complained of as inherent to the filmmaking process, rather than actionable harassment. His view underscored a deep understanding of the industry's unique demands and the collaborative nature of its creative endeavors.
And he's the one, but it turns out because of the letter to SAG, the letter to the Producers Guild,
the PGA letter,
Producers Guild, the underlying text really belie that she really found him. It really sounds like she didn't take him seriously. Right, that's really what it reads in real time. Like, she didn't take him seriously.
Called him a clown half the time. Yeah, there was a lot of nasty stuff.
So if there's stuff that she's not treating him seriously, then is she really being offended, assuming he did something that was severe or pervasive? And that's her issue. That's her issue.
Yeah, I mean, it seems that when I was talking to other lawyers there, like the Lyman's got to decide.
A crucial point Baldoni's defense made was that Lively was hardly powerless. Unlike typical employment harassment cases addressing power differentials, Lively, a major star, held significant influence and agency in the production. This argument challenged the very premise of her vulnerability, suggesting she had ample power to voice concerns or walk away if genuinely uncomfortable. The defense highlighted her stature in the industry, presenting her as an active participant with considerable control, rather than a victim of oppressive circumstances. This key distinction aimed to undermine the applicability of traditional workplace harassment statutes. The question of whether Lively was genuinely offended became a central battleground, and the leaked messages proved devastating. Her own contemporaneous text messages and email revealed she actively sought sexiness for the film, making it difficult to argue she was truly harassed by elements aligned with her own vision. The defense hammered this point, demonstrating a stark contrast between her current claims and her earlier enthusiasm for the movie's mature tone. This undeniable evidence of her original intent severely weakened her assertion of having been personally disturbed by the film's content. The judge strongly implied he did not view Lively's unsigned long-form loan on agreement as enforceable to establish her employee status. This seemingly minor legal detail was a colossal blow, as employee status is critical for most harassment claims under California law. If deemed an independent contractor, her legal remedies would be significantly reduced if not entirely eliminated under the Fair Employment and Housing Act. This legal nuance, often overlooked by the media, revealed a fundamental weakness in her case, potentially stripping her of key statutory protections. Baldoni's attorney, Jonathan Bach, specifically argued that none of the behavior was directed at Lively because she was a woman. Instead, he maintained it was all part of the filmmaking process for an adult-themed movie. This distinction sought to dismantle the gender-based discrimination aspect of her claims, reframing the alleged incidents as creative decisions rather than personal attacks. The defense emphasized the professional context, asserting that any actions were related to the artistic requirements of the project, not a hostile intent targeting Lively specifically due to her gender. Ezra, Lively's lawyer, repeatedly emphasized that she never gave consent for physical touch, even for minor actions like a lean-in or graze. This argument, however, faced an uphill battle against the defense's broader creative environment claims and the judge's own skepticism about defining consent so narrowly in a collaborative artistic setting. The lawyer's persistent focus on granular details of physical contact struggled to gain traction when weighed against the implicit understanding of boundaries in a film production, especially one of this nature. It appeared to overlook the wider industry norms. The defense's argument for implicit consent directly challenged the notion that every improvised moment required explicit approval. They contended that within a creative space, especially for a movie with adult themes, actors implicitly consent to being subjected to the creative process, which might include demonstrations of closeness or physical interactions. This perspective highlighted the fluidity and spontaneity often necessary on set, suggesting that a blanket requirement for explicit consent for every touch would render creative work impossible. It was a powerful counter to Lively's detailed complaints about physical proximity. Lyman is expected to rule that even if the alleged lean-in or graze occurred, it likely would not meet the legal threshold for severe or pervasive harassment. He stated that he could assume the events happened and still conclude, as a matter of law, that they do not rise to the level of harassment under federal or California statutes. This critical legal point bypasses the he said, she said debate entirely, allowing the judge to dismiss claims based on their legal insufficiency, even if he were to believe Lively's account of the events. The first 7 causes of action, which include Fair Employment and Housing Act claims and Title VII claims, are now in severe jeopardy. These are the core sexual harassment allegations that have driven the media narrative, but Lively's inability to establish severe or pervasive harassment, coupled with the evidence undermining her offended status, makes their dismissal highly probable. The elimination of these central claims would leave the lawsuit significantly weakened, effectively stripping it of its most impactful and publicly discussed components. It signifies a major setback for Lively's legal strategy. Baldoni's lawyer, Brian Friedman, faced defamation claims himself for saying Lively weaponized sexual harassment allegations and lied outright. While his statements were made in the press, Lyman drew a sharp distinction between advocacy in court and attacking reputation outside of it, suggesting limits to such commentary. Despite Friedman's argument that he was expressing opinion as an advocate, the judge appeared unpersuaded, hinting at potential liability. This side battle added another layer of complexity, indicating the judge's intention to scrutinize the conduct of all parties involved, even legal counsel. Stupiro, Friedman's attorney, warned Lyman to tread carefully, arguing that punishing an advocate for press statements could chill protected lawyers from doing it. He emphasized that the public needs to hear various perspectives from legal professionals. However, the judge's stance indicated he viewed Friedman's comments as exceeding the bounds of mere advocacy, moving into territory that personally attacked Lively's character and motives. This legal tightrope walk highlighted the tension between free speech for attorneys and the potential for reputational harm, adding another high-stakes element to the ongoing legal drama. The narrative of Lively being a helpless employee facing oppressive conduct has been thoroughly dismantled by her own internal communications. The letter to SAG and the underlying text reveal a stark contrast to her public claims, suggesting she didn't take the alleged incident seriously in real time. This profound inconsistency severely damages her credibility, painting a picture of someone who actively shaped a project's adult content, while later claiming offense from its execution. The discrepancy between her actions and allegations makes her position incredibly difficult to defend. With trial dates looming in May, Lyman's ruling on the motion for summary judgment is expected soon, potentially before the end of March. Should a significant portion of Lively's claims be dismissed, it would drastically alter the trajectory of the case, potentially leading to settlement discussions or a much narrowed trial. The impending decision holds immense weight, as it will determine whether this high-profile legal battle continues to trial with its current scope, or if it quietly fades after a judicial determination. Everyone awaits the judge's final word, which could reshape the entire conflict. The strategic exposure of Lively's own messages, once private, became the most powerful testimony against her, creating a domino effect that continues to unravel her case. This dramatic turn of events, where her own words undermined her allegations, exposed the fragility of her claims, and underscored the critical importance of consistent narratives in legal battles. The courtroom clash revealed how easily a meticulously crafted public image can shatter when confronted with irrefutable private truths, leaving a lasting impact on how such high-stakes disputes are perceived.